Good morning. The Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Bettencourt, Birdwell, LaMantia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Good morning. The chair lays out this time Senate Bill 2509 and recognizes its author, Senator King, to explain the measure. We'll be moving through the agenda this morning, hearing bills from non-members of the committee who are present, and then we'll move through the rest. And if you wish to testify on for or against after the senator's layout, please register at the kiosk just outside this room. And we do have 3 witnesses already signed up. Good morning, Senator King. Welcome. Explain your bill to us, please.
Thank you, Mr. Chairman. Members, as you recall, the legislature, with Senator Hughes's strong leadership, passed HB 20 in the second call special session of the 87th, and it gave Texans the right to sue for an injunction if their viewpoints had been censored by social media platforms. The legislation created consumer protection scheme or mechanism requiring the social media companies to create public disclosure around their censor practices and to have transparent and acceptable policies for all users that all users could be aware of, and to have a complaint and appeals process wherein users could actually go to court or the Attorney General could go to court and get an injunction to stop that behavior. Now, while HB 20 did give individual Texans the right to enjoin their posts being censored, it did not give them a remedy if the social media platforms failed to meet their obligations under the Consumer Protection portion of the legislation. The Texas Deceptive Trade Practices Act, DTPA, specifically exists to protect consumers from market abuses such as this, and the Attorney General has some statutory authority to investigate potential violations of the DTPA practice laws, except that the Attorney General's office does not with regard to this social media issue. SB 2509 would take a small step further in dealing with this social media censorship by giving individual Texans a remedy to enforce the consumer protection provisions of HB 20 by creating a new cause of action under the DTPA, and by giving the Office of the Attorney General the same authority to investigate violations of the HB 20's consumer protection provisions that their office now has to investigate antitrust violations. And Mr. Chairman and Senators, I have one invited witness here today who's an expert in the field that can answer all the technical questions, and that's Scott McCullough.
Thanks, Senator. Members, any questions for the author? Excellent. Thank you very much. We'll call your invited witness. The chair calls Scott McCullough. No stranger to this committee or this building. Welcome back. Introduce yourself. Give us your testimony.
Yes, sir. Mr. Chairman, members, nice to be back. My name is Scott McCullough. I'm here speaking on behalf of Texas.net in favor of the bill. We were involved last time around with HB 20 with Chairman Hughes' leadership, and then over at the House. We were all very, very cautious that time around, still taking baby steps on all this. And we were hopeful that the social media companies might kind of see the light and change their ways. But with one perhaps exception, they're still misbehaving. And what we've discovered is that while the injunctive relief was good for a going forward purpose, it did not provide for damages on an historical basis, whether they be for emotional distress or if they be economic damages. It's important to recall that there were 2 major portions of the bill, Section 2, which was the consumer protection part, and then Section 7, which was the censorship part. This bill before you now addresses the consumer protection provisions that were in Section 2. And consumers can still bring these actions today, notwithstanding the federal district court injunction against the Attorney General. What this bill would do is allow consumers who have been damaged to bring an action not only for injunction but also for any economic damages, any emotional distress that they may have suffered as a result. It also gives the Attorney General additional discovery type powers similar to those in the antitrust statute. The traditional CID powers, a long time ago I had the opportunity to use them. They're equivalent to requests for production in the discovery rules in district court. This would give him the ability to do interrogatories and depositions, along with some other things as well. This is a good bill, and we ask that you pass it. Thank you.
Thanks, Mr. McCullough. Senators, any questions for our witness? Thank you for being here. We'll open public testimony, and the chair calls Shan Turner and Robert Green. Shan Turner and Robert Green. Mr. Green, welcome. Welcome back. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Bob Green. I am the chairman of the Travis County Republican Party Election Integrity Committee for Legislation. Once again, we come to the point of trying to establish a system where we have an enforcement of a law. We have bills today that will deal with actually moving a change of venue, because we have DAs in some of our largest Texas cities that will refuse to prosecute violations of the election code and have reduced many felony offenses down to misdemeanors. We need to have the ability to move outside the county to another DA who will move the enforcement of these along, and without, and I've repeated it several times, without significant prosecution and enforcement of our laws, our election laws and everything else, what benefit is any law? And so that's where we are today. So yes, I'm definitely in favor of this bill, and ask for your recommendation to the full Senate that it do pass. Thank you.
Thank you for your testimony. Senators, any questions for the witness? Thanks for being here. And the chair calls, once again, Shan Turner. Shan Turner had registered as wanting to testify for the bill. We'll show Shan's position, not testifying, but for the bill. Those are all the witnesses we have registered. Is there anyone else wishing to testify on, for, or against? Looks like Mr. Johnson back there. Come on down. So we're on 2509, Senator King's bill. Did you already register, Mr.? I know you know the system better than we do. Do you?
Yes.
Very good. Go ahead and testify, and if you will, do a paper.
Make sure I'm on the right bill. This is the one for prosecuting outside of the DA out of the county? No, okay, I'm sorry.
No, there's a lot of overlapping issues this time. No problem. No, better safe than sorry. So anyone else present wishing to testify on, for, or against Senate Bill 2509? Seeing none, public testimony is closed, and the bill is left pending at this time. The chair now lays out Senate Bill 1884, and recognizes its author, Senator Flores, to explain the measure.
Thank you, Mr. Chairman. Remember, that's a long way down there in this table from here. But anyway, good to be here with you all. This Senate Bill 1884 is a Texas Engle list. So I do have a committee substitute to lay out as well, Mr. Chairman.
The chair sends up the committee substitute and recognizes the author to explain the substitute.
So, Mr. Chairman, members, Congress passed the United States Northern Triangle Enhanced Engagement Act in 2020, which requires the United States Department of State to provide an annual report known as the Engle List on corrupt and undemocratic actors in the Northern Triangle countries. This report is used to hold corrupt actors accountable using targeted economic and trade sanctions such as asset freezing and denying of visas. Due to the foreign corruption spilling over into Texas, especially from our southern border, Texas can and should create its own version of the Engel List, one that is focused on tracking and monitoring corrupt and dangerous actors doing business in Texas. Senate Bill 1884, committee substitute, seeks to establish such a list by requiring the Secretary of State's office to post a report on its website identifying foreign nationals who have engaged in actions that undermine the security and sovereignty of the state or in significant corruption in their home country. Sanctions can then be imposed on an individual or affiliated entity by denying an application for or revoking any business registration obtained to do business in this state, prohibiting contracts with state agencies, prohibiting attendance in public institutions of higher education. The bill does provide for the Secretary of State to notify a person that will be on this annual report and to establish a procedure for an individual who seeks expungement of their name from this report. The state of Texas is under the strongest incentives to hold those who take the path of corruption accountable and shine a light on them if they are undermining the rule of law. Committee Substitute 1884 will do just that. Thank you, Mr. Chairman, members, for consideration. Committee Substitute for Senate Bill 1884.
Thank you, Senator Flores. Members, any questions for the author? Very good. We'll begin testimony. Very good. We'll open public testimony. As we do that, I'll note that we have a resource witness here from Secretary of State. Does anyone need to hear from the Secretary of State on this bill? Very good. We'll open public testimony, and the chair calls Melissa Ford. And Melissa is the only remaining witness we have registered on Senate Bill 1884. So if you wish to testify, please step to the kiosk outside the chamber and register there. And go ahead and have a seat, get comfortable, and introduce yourself. Give us your testimony. Welcome.
Hi, thank you. Dear Chairman Hughes and members of the committee, thank you for the opportunity to testify in support of Senate Bill 1884. My name is Melissa Ford Maldonado, and I'm a policy director at the Texas Public Policy Foundation. In my role, much of my work focuses on Mexico policy, specifically organized crime, drug trafficking, trade, and corruption and collusion by state actors within Mexico. Our latest research provides a deep dive into the complex dynamics of corruption in Mexico and sheds light on the Mexican state's willing cooperation with drug cartels. Our southern neighbor ranks among the top 5 most corrupt countries in the world, and its industrial scale level of cartel-driven corruption is a direct threat to the U.S., especially Texas, since we share such a large stretch of border with them. Tomás Yarrington Rubalcaba, César Horacio Duarte Jaques, Genaro Garcia Luna. These are the names of only a couple of the high-ranking Mexican government officials who violated their oath of office, weakened Mexico, and betrayed their country by living a double life and taking millions from the violent drug cartels that they should have been fighting. Sadly, there's no shortage of them. The common thread between these individuals, governors, cabinet secretaries, presidential candidates, is that they not only wrongfully filled their pockets with dirty money, but used it to directly harm Texas families and communities. SB 1884 allows Texas to bring accountability to corrupt individuals like them, a class of people who have long escaped the accountability and justice that they deserve. The passage of this bill would send a message to corrupt foreign nationals who need access to the Texas economy to increase their wealth and access to Texas society to enjoy it. SB 1884 is a necessary first step in the process of weeding out foreign corruption in Texas and would contribute directly to the safety and security of Texas communities. Mr. Chairman and committee members, I want to end by saying that I come before you today as a witness to the devastating impact of corruption on my home country of Bolivia. I can tell you from personal experience that corruption is far from a victimless crime. It rips apart communities, destroys democracies, and in the end only serves the interests of criminals. Texas must not turn a blind eye. It is imperative that we take action to combat corruption and safeguard our communities from its destructive effects. Thank you for your time. I'm grateful for your leadership and for your consideration of SB 1884, and I'm happy to answer any questions you may have.
Thank you for your testimony and for sharing your own experience, and that means a lot. Senators, any questions for the witness? Thank you for being here.
Thank you.
There's no one else is registered to testify on, for, or against Senate Bill 1884. Is there anyone else present wishing to testify on, for, or against Senate Bill 1884? Seeing none, public testimony is closed.
Thank you, members. Appreciate your support and recommendation to the full Senate.
Thank you, Senator. Senate Bill 1884 will be left pending at this time. Drew, do you care which one's first?
Number order's fine with me.
The chair lays out Senate Bill 569, and recognizes its author, Senator Springer, to explain the measure.
Thank you, Mr. Chairman and committee members. Public Information Act allows for governmental bodies to recover costs related to reproducing public information. However, there's a loophole in the PIA costing taxpayers thousands of dollars. Based on Texas Civil Practice Remedies 22.004, when a city receives a summons for a lawsuit, even though the city is not part of the lawsuit, the city has to produce all the documents at no cost. The bill matches the Texas Civil Practice and Remedies statute with the PIA so that the loophole is closed. I have an expert witness, Caleb Garcia, who's the deputy attorney from Denton, that can testify to the technicalities of the loophole. And I think this is just good government. So I think if our taxpayers realized that they were paying for all these reproductions of deals that city wasn't involved in, they would probably wonder why they're doing that with their tax dollars. But with that, I would be happy to answer any questions.
Thank you, Senator. Members, any questions for the author? Very good. We'll open testimony, and the chair calls Caleb Garcia as invited testimony. Mr. Garcia, welcome. Get situated there and introduce yourself and give us your testimony.
Thank you, Mr. Chairman. Good morning, Chairman and members of the committee. My name is Caleb Garcia, and I'm pleased to represent the City of Denton in testimony in support of SB 569. Currently serve as Deputy City Attorney for the City of Denton. In my current role, I coordinate the litigation on behalf of the city, including responding to all these subpoena requests we receive for documents. Texas municipalities regularly receive subpoenas for documents from these third-party attorneys on legal cases where the city is not a party. These requests include a lawsuit where two parties involved are such as personal injury, car accident, property law cases, as well as one particular case we received a subpoena on where one of our city vendors was involved in a lawsuit unrelated to the work for the city, and that particular plaintiff sought every record we had in our possession regarding that vendor, even though the lawsuit was unrelated to any work he did for us. In many cases, these requested documents are extensive and require a significant amount of staff resources to collect and review prior to distribution. One subpoena request was over 50 pages long and had 30 separate requests for documents to the city. As a litigator, I know that a majority of these large-scale requests for documents will not lead to any admissible evidence in court and are really just free fishing expeditions by requesting counsel with nothing to lose and no real out-of-pocket expense for doing so. As stated, these requests take dozens of hours of staff time to complete, and it's on behalf of other work that we're trying to do for the community. Unfortunately, currently under Chapter 22 of the Civil Practice and Remedies Code, the city is only allowed to charge $1 for production and certification of these documents in compensation for all said resources. So as a result, the Denton community members foot the bill for these third-party subpoena requests. By comparison, members of the community and general public who request documents under the Public Information Act are often required under Texas law to pay a fee commensurate with staff resources. This fee is to ensure that other taxpayers do not subsidize the cost of these requests and help reduce the vexatious requesters that cities receive. By ensuring document requests via this third-party subpoena are required to pay a fee no different than members of the Denton community and the general public. SB 569 will ensure that taxpayers do not subsidize staff resources to fill these document requests, and that those issuing these third-party subpoenas pay the actual costs of the request for the work they're seeking. Thank you for your time and consideration for this bill.
Thank you for your testimony. Senators, any questions for the witness? Thanks for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 569? Seeing none, well, let me back up. We're going to formally open public testimony and ask, is there anyone present wishing to testify on, for, or against Senate Bill 569? Seeing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 815 and recognizes its author, Senator Springer, to explain the measure.
Thank you, Mr. Chairman and committee members. Ranchers and farmers, both landowners and lessees, are currently liable for damages caused by natural disasters and events outside their control, caused by people who trespass illegally on their property. And this has been heightened as conditions in the border have gotten worse, an increase of incidents of fence cutting, chases that have led into fence damages. And what we see is animals get out, they get on the roadway, somebody hits the animal, and they come back and hold the landowner liable for that. These individuals have illegally and unlawfully entered the premises, and they're doing it not only on the border but across the state. This bill adds the new definition of trespasser in Section 75.006 of the Civil Practice and Remedies Code, where landowners are not liable for damage caused either directly or indirectly to other property by trespassers who cut fence, damages damages caused by vehicles or other means, police actions where the police are chasing people across, and wildlife in the act of gods, negligence of landowners, including those who do not properly maintain their fences, are not, and I repeat, are not protected by this act. And we have expert witnesses from the cattle raisers that can address any legal questions members might have surrounding those. But with that, I'm happy to answer any questions. I'll also note that this is a companion bill to House Bill 73, which is on the floor of the House today. And so if you look favorably upon this, I would ask that we hold off on voting it out and let the House bill come on over.
Thank you, Senator Springer. Senator Birdwell, you're recognized.
No, not a question, Mr. Chairman, but just an endorsement of what the good senator's doing. We saw this problem in all my trips down to the border, the damage done by bailouts and fence cutting and everything else. And right now, the property owner is left with the responsibility, as Senator Springer has said. So this is a very good bill. I would urge the support of the committee and the full Senate. Thank you, Mr. Chairman.
Thank you, Mr. Chairman Birdwell. And I would say it's probably more prevalent in Senator Lamatia's and Zaffarini's district, but that does not mean it has not happened at the northern border, at the Oklahoma side, on mine as well, and in my rural parts of my district where we've seen these acts as well. So it is a statewide needed action.
Thank you, Senator. Members, any other questions for the author? Very good. We'll open public testimony. And the chair calls Martha Santos, Arthur Ull, and Ed Johnson. Well, good morning. Welcome. We'll begin over on my left, your right, if that's okay, and introduce yourself and give us your testimony.
Good morning, Chairman Hughes and members of the committee. My name is Martha Santos. My family used to run a ranch in Laredo and still owns agricultural land there. I'm currently a landman for an energy services company and live in Fort Worth. I'm here today representing myself and TSCRA in support of Senate Bill 815. My family ranched for generations in Laredo, but as the city grew and other changes happened, some of our land got rezoned and became commercial in nature. We still have agricultural land directly on the river, and I have had to give up on having anything on our property. Border Patrol has warned my family and I not to be on our land at any time of the day because it is such a high-traffic area for guns, people, and drugs. The fence line was constantly being cut due to foot traffic, and it became impossible for us or anyone to keep up with. On top of all these hardships, my family and I were and continue to be liable for damage caused by the individuals who trespass on our land. Not having cattle reduces the liability risk for us, but for our neighbors who continue to ranch, their liability is significant. They are liable for the damage, direct or indirect, created by those who take down or damage their fences and trespass on our land. For example, if someone cuts one of our neighbor's fences in Laredo and a cow gets out on the road and a person gets hit by that cow, the rancher is liable for any damage caused by that cow. That is unfair and, quite frankly, a burden that landowners in Texas, especially in the southern part of the state, can no longer bear. Ranchers are tough. We can shoulder the challenges of drought, bad calf crops, bad weather, increased input costs, etc., but adding liability for damage that is not our fault is one burden too many. I don't know if my family will ever be able to run cattle on our land again, but I think it is important to share our story and advocate for changes that can be made to help ranchers in our area and across the state. Senate Bill 815 helps ranchers across the state by limiting their liability in certain circumstances when the damage is beyond their control, and it is vital to the continued financial feasibility of ranching in Texas. Thank you, Senator Springer, for authoring this important legislation. Thank you, Senator Zaffarini, for your continued support and friendship to the district where my family lives. And thank you to all of the committee for taking time to listen. Thank you.
Thank you for your testimony. Good morning. Introduce yourself.
Good morning.
Give us your
Good morning,
testimony.
Chairman Hughes, members of the committee. My name is Arthur Uhl. My family and I ranch near in Schleicher County near Fort McCabe. I also serve currently as the president of the Texas and Southwestern Cattle Raisers Association. I'm here today to represent both myself and the cattle raisers and wish to speak in support of Senate Bill 815. TSCRA is a 146-year-old trade association and is the largest and oldest livestock organization in Texas. TSCRA has more than 26,000 individuals and businesses and members that contribute to the production of beef and stewardship of our natural resources throughout the Southwest. One of the ways TSCRA engages with our members is to find out what challenges they are facing and how we can help. And to that end, we formed a border security task force last summer made up of 14 cattle raisers, members, and leaders. The task force reached out to hundreds of ranchers and landowners to get a better understanding of the practical challenges they were facing day to day going about the business of raising cattle and managing ranch land. Nearly 365 members responded to our survey, and the results show that 78% of them were being directly impacted by the current situation. The direct impact included cut fences, vehicular damage to fences, trespassing on private property, and abandoned trash and litter. These kinds of activities create damage both directly and indirectly, resulting in losses of time, resources, and money for the ranchers in the area. But what is worse, ranchers and landowners are also currently liable for any damage caused by these actions, even though the people that caused the problem and the damage is beyond their control. Seeking a solution to this issue, cattle raisers worked with stakeholders and its members, and we soon realized that ranchers' liability concerns span across the state. In other words, a discussion about a regional issue led us to discover that the overall issue of liability impacts almost all of our members across Texas. Ranchers believe in being good stewards of the land and being responsible landowners. However, even when they're fulfilling all their duties, they face this liability for actions beyond their control. That means that in addition to dealing with the drought, the daily and never-ending challenges of ranching, and the cost of the damage itself, our members have to worry about liability for things beyond their control. SB 815 solves this problem by removing ranchers and landowners from liability in limited circumstances when damage is caused by trespassers or other sources out of their control. It is an important bill for the sustainability of ranching and farming and Texas agriculture. Thanks to Senator Springer for authoring this legislation, and thanks to all of you for your time. I'll take any questions.
Thanks for your testimony. Mr. Johnson, welcome back. Introduce yourself. Give us your testimony.
Yes, Ed Johnson, and I'm here in support of SB 815. Y'all know me as the election guy that runs Harris County, but on my weekends, I used to moonlight as a rancher. We have a family ranch here in Giddings, Texas, about 1,000 acres, and had numerous problems of this. The ranch has 77 on one side, a railroad on the other side, and Nails Creek. Just last month, there was a armed robbery in Giddings. The people that did it ran down the railroad tracks, jumped across the creek. The police were chasing them with dogs, cut my fence down, and my cows got out across the creek over to the neighbor's peanut ranch, and he held my cows until I paid him for the damages done. Now, you know, the police in pursuit ended up tearing my fence down. They did it. I've had numerous times where on 77, cars in a turn go right through the fence. They don't stop and tell you. In fact, the last one went through the fence, drove across the field, went through 2 other fences, and came back out the other side on another fence. The sheriff said unless he pulls his license plate off, we have no idea who it is. And then my cow got out and was hit by a truck. I was out a $2,000 cow and civilly liable now in a suit. I have to carry a $2 million insurance policy on my place just to protect from damages like these that are no fault of my own. I've had times when the drought, the train coming by has set fire to the field, burned the fence down, the cows get out across the road, and once again had one get hit. Now, thankfully, that guy didn't sue. He was a neighbor. But, you know, it's loss of damage, and then you're legally responsible for this. It's not fair. And you're looking at a ranching industry, at least in Central Texas, that hasn't made a profit in the last 4 years during the pandemic. So you're taxing this upon ranchers that are having a very difficult time making a process of being legally liable for somebody else's actions on their place or trespassing. This would be a great bill, one of the best bills y'all have had this session, so to help relieve ranchers and farmers. Thank you.
Thank you for your testimony. Senator, is there any questions for any of our witnesses? Senator Zaffarini, you're recognized.
I have a question for Ms. Santos. Welcome to the Senate. Glad to see you here.
Thank you.
I know that you support the bill, but is there a way that you could make suggestions regarding how it could be even better for you and people who suffer what you do?
I think it's great as it is. I know there was a few changes that they made to the House bill just to clarify on the wording, but I think it's a solid move to help protect ranchers on the border and honestly statewide.
So Senator Springer has a perfect bill?
It's pretty solid.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you, Senator. Members, any other questions for our witnesses? Thank you for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 815? Seeing none, public testimony is closed, and bills left pending at this time. And it's our intent to, and we're waiting for the House bill. Is that right, Senator? That's correct. Very good. Thank you. At this time, the chair lays out as a matter of pending business Senate Bill 397. Members and those following the committee will recall this is Senator Hall's bill. He's done a lot of work on, and we're going to recognize him to lay out a new committee substitute. So we're on 397. The chair now sends up a committee substitute. Recognize Senator Hall to explain the new committee substitute.
Thank you, Mr. Chairman and members. Early voting counts for over 50% of the votes cast in most counties. In the past, the Secretary of State has interpreted current law as prohibiting the printing of result tapes at the voting location immediately after the polls close on the last day of early voting. This leaves a serious gap in cast vote accountability. The committee substitute for Senate Bill 397 will close that accountability gap by establishing a hard copy record of the precinct vote. Section 33.056 Election Code authorizes a poll watcher to inspect election returns and other records. New committee substitute for SB 397 makes it clear the poll watcher is entitled to inspect the tapes along with the judge as a part of the authority. Additionally, the substitute specifies that the mere printing of the result tapes after the close of the poll on the last day of early voting by personal appearance does not constitute the offense of unlawful revealing before the poll is closed. And with that, Mr. Chairman, I'd be happy to take any questions.
Thank you, Senator. Senator Bettencourt.
Bob, excuse me, Senator Hall, you've been working on this for a while. The concept of printing zero tally tapes, okay, has been around for a long time, because the fact of the matter is that that's a positive lock on what was happening with the machine at any polling site, true?
That's correct. But by this puts us in the position of having zero tapes, which is currently being done, which tells us there were no votes in the machines. And then as soon as the polls close, we'd be able to anchor what the votes were that were cast, and eliminates that wonder and less concern about the chain of custody during that 4-day gap.
Right, and so, and we know we had a lot of discussion last time it was there. Is there an automatic way to store that at this point in time, or are you just saying, print it and seal it under penalty of, death by phase or whatever is necessary to keep people?
Yeah, it suggested there might be a way to print it and seal it. There's no machine that exists that's certified right now. We're going to be asking the Secretary of State to develop a certified machine to do that. In the meantime, it'd be sealed right there at the precinct when it's printed.
Okay, thank you.
Thank you.
Thank you, Senator. Members, any other questions for the author? Very well. Thanks, Senator Hall.
Thank you very much.
And Senate Bill 397 will be left pending at this time. And I'll say, members, for the benefit of you and your staff, we will probably be voting today. We'll probably have a desk vote after session today to consider pending business. And so just as you plan your day. Returning now to the agenda. The chair lays out Senate Bill 1817, 1817, and recognizes its author, Senator Bettencourt, to explain the measure.
Thank you, Mr. Chairman and members. I do have a committee substitute.
The chair lays out the committee substitute and recognizes the author to explain the substitute.
Thank you. It's been over a year since the Russian Federation invaded Ukraine. Due to the Russian Federation's continued countywide assault on Ukraine last February, 33 states have taken action to either impose sanctions or divest from the Russian Federation, or both. Texas took action too. All 31 senators signed on to a letter to Lieutenant Governor requesting an interim change to study the feasibility of the state comptroller preparing and maintaining a list of all companies that invest in Russian Federation. In response, Comptroller Hager requested the Texas Treasury Safeguard Trusting Company to review investments in Russia, and these, of course, were the listing of entities involved with state government. At this point in time, former Senator Hager, now Comptroller Hager, has done a tremendous job of driving divestment from the Russian Federation from our own funds. Specifically, as of May of 22, we had a large exposure before that, but we're now down to basically almost nil from the standpoint of direct or indirect investment in Russia. At this point, the committee substitute for Senate Bill 1817 would ensure the state of Texas joins the other states from around the country in divesting state investment funds from the Russian Federation. The bill would ban state investment funds from being invested in businesses that have any form of commerce with the Russian Federation. It does two things specifically: clears up the language from the exception to ensure that Texas doesn't divest from oil and gas companies as well as medical companies conducting humanitarian work in Russia. It also includes language of the governor. Consultation with the Security Council can remove Russia from the list of banned companies. And there was a drafting error that we got back late last night that we'll have to clean up with a floor amendment on that. But we have Mike Ressig here from the Comptroller's Office as a witness. if you need any testimony, Mr. Chairman.
Thank you, Senator Betancourt. Members, any questions for the author?
What's that? No, it's not. Okay.
We'll open public testimony on Senate Bill 1817. The chair calls Hasib Abdullah. Hasib Abdullah. And Hasib is the only witness we have currently registered on for or against Senate Bill 1817. So if anyone wishes to testify, anyone else, please go to the kiosk outside the chamber. And we want to hear from you. Welcome. We'll give you a minute to get situated there. And when you're ready to introduce yourself and give us your testimony.
Thank you, Chair. My name is Hasib Abdullah. Thank you for your courtesy and hospitality. Chair, members, my name is Hasib Abdullah. I am a resident here in Central Texas. I'm representing only myself, and I am against this bill for a couple of reasons. I know every senator has voted on this, so I'll give my 2 cents, as I say, briefly. I think this is a little bit of I say this respectively because all the senators did this. It's a little bit of virtue signaling in the sense of causes untold employee hours just to make this change of statute. For example, public entities will have to go in and make sure Russian Federation is in there along with the other additional U.S. Department of State entities that have been there for years. And collectively, over the long term, that could be untold hours, maybe thousands of hours, that is government, in my opinion, could be government overreach. I will say that the federal government already determines what is foreign affairs under the U.S. Constitution, in my opinion, and I think this is kind of going into it a little bit, or a lot of it. And I think the leadership in Russia now is the same leadership they had for 20 plus years. The individual who was in charge of the Chechnya war, that untold destruction, death, and all the other bad stuff, that might have been something that legislatures, not in statute, but maybe as a resolution, should have done at the time. And maybe instead of doing a statute, maybe doing a resolution as well, saying they condemn this war and that type of thing, and that Texas will always condemn these types of actions. But I would say that the leadership in Russia can change at any moment, but the legislature only shows up every 2 years. So we may not want something like this, and it'll take another 2 years to come and change it, perhaps. Those are my thoughts, and thank you, Chair, for your time and service.
Thank you for your testimony. We always want to hear from folks, and thank you for being here. Any questions for the witness, senators? Very good. Thank you. Anyone else wishing to testify on, for, or against Senate Bill 1817? Seeing none, public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 2208, and recognizes its author, Senator Parker, to explain the measure.
Thank you, Chairman Hughes and members. Great to be with you all this morning. Election crimes carry a great deal of political contention and deserve to be heard in an unbiased venue. In most cases, current law requires election crimes to be prosecuted in the county in which they occur. The concern, however, is that the prosecution of election crimes is particularly susceptible to bias due to the power held by the offices whose elections are being questioned. Further, juries in these counties may be more biased as the outcome personally affects them. By allowing election crimes to be held in adjoining counties, the case is more likely to receive a fair and unbiased venue. Thank you, Mr. Chairman and members, for the chance to come before you today with Senate Bill 2208.
Thank you, Senator. Senator Birdwell.
Thank you, Mr. Chairman. Senator Parker, would you walk us through, because I certainly agree with the concept, but I'm trying to figure out in practicality, how does it functionally operate?
Sure.
Does the regional presiding administrative judge make such a determination? How does a district attorney in another jurisdiction receive such a case? Walk us through what that looks like, because while we say we have the authority to do it, how does it actually occur?
Sure. Well, of course, concerns about election crimes are unique
in a particular venue, they can be particularly politically sensitive. And I'm sure you've experienced in your time of service, as I have, a number of folks that had concerns, but they were concerned about impacting the balance of relationships in a particular area in which they served. And for that reason, I believe this to make great sense. Now, procedurally, what we're talking about is just adjoining counties. So counties that would be next door or touching a county, the DA in that particular county would have the discretion and the ability to bring forward the case. So we don't overly complicate it. We just allow that DA in a neighboring county to be able to come forward.
But does that mean that the DA of is it basically the DA of the originating county recuses himself, sends it to that neighboring DA, or because we have circumstances where we've got DAs that refuse to prosecute something, not because of a recusal process, but
in the way it's currently drafted, and we can work as a committee on it, that wouldn't be, you wouldn't have to see a recusal occur. You would just allow the DA could take action, the neighboring DA could take action, regardless of whether or not the DA in the county where it took place was going to be cooperative or not.
So then the plaintiff in the case would actually file in the neighboring county. Rather than the neighboring county's authority moving it, the plaintiff has to go file in the neighboring county, and then that neighboring DA then has the discretion to take the case or not.
That's correct. I mean, think about the kind of venue shopping that people do today in various cases, right? And providing that kind of flexibility. To me, I think it's when the balance of powers, I think it's appropriate. But yes, what you just described is accurate.
Right, okay. Thank you. Thank you, Senator.
Thank you.
Thank you, Senator Birdwell. Members, any other questions for the author? Very good. We'll open public testimony on Senate Bill 2208, and the chair calls Robert Green, Susanna Carranza, looks like Dr. Carranza is coming down, and Ed Johnson.
Mr. Chairman, members of the committee, I want to take this opportunity to apologize because the testimony that I gave earlier on 2509 should have been on this bill. I was completely just messed up. But anyway, my name is Bob Green.
There's certainly related concepts, and what you said made sense, and so no problem, but thanks for clarifying.
I realize that, and I would ask the committee to please put that testimony in favor of this bill here.
No problem. No problem.
I would only add that based on the situation of these DAs who may not want to prosecute in situations of significant violations of our Texas election code, I think it's incumbent upon the legislature to create an alternative pathway to enforcement of significant violations of the code. And the utilization of DAs in adjacent counties would seem to resolve this issue, to be able to go out and in an adjacent county and bring forth a significant prosecution or indictment and prosecution on significant violations of our family code, our election code. We need to have enforcement. Otherwise, as I said, what benefit is any law if you don't enforce it? And if no one cares, and no one cares if they're going to be. So I would ask for your favorable consideration of this bill and to please pass it along to the full Senate with a recommendation that it do pass. Thank you.
Thanks for your testimony. Mr. Johnson, go ahead.
Yes, Ed Johnson, and I'm here in support of Senate Bill 2208. As you know, I worked in Harris County elections for over 20 years under the great tax collector assessor Paul Bettencourt as director of voter registration. And in those years, after every election, the code requires you to compile a list of people that voted illegally and submit it to the DA. And we would do that after every election. And to come find that the DA would not prosecute or very rarely even look into any of these cases. In my experience in working in Harris County elections, anytime there was an election case that was brought forward for prosecution, the judge, I don't know if it's a written rule or unwritten rule, but the judge always recused themselves and brought in a judge from a neighboring county. They never heard them case themselves because they are an elected official, and as an elected official, they can't serve or hear an election case within their own county. Now, we're putting the DA under a tight wad there. That's why the DAs in these counties don't prosecute it. They're an elected official too. And we're asking them to prosecute an election crime when they're on the ballot. So by allowing a neighboring DA the ability to look into prosecute this case, it relieves that responsibility or that liability that this DA has of being on the ballot and prosecuting an election crime by having a DA that's not on that county's ballot that's looking at the crimes. It makes all the sense in the world. We're already doing this in the court system. Why don't we do it with the DAs too?
Thanks for your testimony, Dr. Carranza. Welcome. Introduce yourself. Give us your testimony.
Hi, I'm Dr. Susana Carranza. I'm testifying on my own behalf, and I oppose this bill. There's discussion saying that this is to solve politicization, but I think this actually will make the problem worse because it sounds more like allowing for venue shopping. You just kind of go find where somebody decides that case will be more very favorable in one place. The other part that it's the bill is not very clear how the process works. There was even the question in the beginning for clarification, but the bill is stated, doesn't say who decides which county is going to do it. It doesn't request the DA to recuse, as he mentioned, like in the current law, you have to recuse for conflict of interest, but this bill does not require the DA to recuse or have any say. So any county, like there are some counties that are surrounded by 6 other counties, who decides who is going to hear that case? To me, it seems like a free-for-all. It actually makes the problem, like if there is any issue with politicization, this will make it even worse because there's no standards, no rules, and you could have a tiny county somewhere that could be calling from different counties. Right? I mean, have you looked at the map? Like there's most counties in Texas have like 5-6 counties surrounding them. I think this would be mayhem. It would be similar to venue shopping, and it will cause more problems than it tries to solve. Thank you.
Thanks for your testimony. Senator Zaffarini.
Thank you. In your opinion, could the district attorney from Harris County or from Travis County prosecute any case in any adjacent county?
I'm sorry?
Could the district attorney from Harris County or Travis County, in your opinion, prosecute any case in any adjacent county?
A county, according to this, any county the Harris could go choose to prosecute any of their surrounding counties because it works like maybe the way this bill was intended was to say that the smaller counties around big counties would be doing the prosecution, but absolutely it cuts both ways.
That was my point. It does cut both ways.
And it's mayhem in any case because you do not want, there's a reason we elect judicial positions, and unless the person in that jurisdiction decides there's a conflict of interest because the case involves their own election or something like that, it's just allowing, without any rules, somebody from the neighboring county to do it. It's just terrible. And again, it cuts both ways. It could be a big county prosecuting small counties' offenses and a little county and big counties. Different political persuasions, and it's like, why do we elect judicial officials if they are not going to be able to rule how they were elected to rule. Again, if it's their discretion to recuse themselves, it would be different, but this doesn't even allow that.
Thank you. Would the other two witnesses care to comment?
Sure. Ed Johnson. I think the bill is written very well. It doesn't put a lot of technicalities into it, so you're correct. Harris County or Travis County could, prosecute any of the cases in their 8 surrounding counties. But you're not going to have a lot of counties that are going to want to jump into this because they're going to, take on the cost of the case, of hearing the case. It's going to be heard in that county. So you're not going to have counties lined up wanting to take these cases. I think it would only be when you have really extreme, cases or really obvious cases of election fraud that are going on or election misconduct that you would possibly end up in another county with the case. We basically had these rules in place before, and they were working very well until the Supreme Court ruled differently for the AG. The AG was taking them to other counties, and it was working very well. So it allowed the DA not to have, a DA can recuse themselves, but they can't have their whole staff recuse themselves because there's no one to prosecute the case. So by allowing it go to another county, it took the DA out of being in the pinch of being on the ballot and their office, possibly upsetting one side or the other. So it makes a whole lot of sense to do this.
Thank you.
We wanted to, I'd like to point out that so that there is no political vested interest that a DA in one county might have to not prosecute a case, I think this gives us a pathway to go forward with a prosecution of a significant violation of the election code.
Thank you. Thank you all. Thank you, Madam Chair.
Thank you all very much for being here.
Pulled a fast one on you there, didn't we?
Did.
Thank you, Senator Zaffarini. Members, are there any other questions? Thank you all for coming today. Appreciate it so much.
Thank you all.
Is there anyone else wishing to testify on, for, or against Senate Bill 2208? If not, then public testimony is now closed. Bill will be left pending, subject to the call of the chair.
Yes, ma'am.
The chair now lays out Senate Bill 2146 and recognizes the author, Senator Parker, to explain the bill. Is there a committee sub, Senator Parker?
There is not a sub.
Okay. No. Thank you. Go ahead.
Good morning, Madam Chair and members. Senate Bill 2146 seeks to ensure transparency from financial institutions that plan to divest from Texas oil and natural gas by requiring them to submit a signed statement to the Comptroller of Texas signifying their commitment to not divest in these industries. Divestment from these industries has the potential to significantly impact the state's economy and the livelihood of many, many Texas residents, making it important for financial institutions to be transparent about their plans and the reasons behind them. Senate Bill 2146 would require all financial institutions in the state that operate mutual funds to submit a signed statement to the Comptroller of Texas signifying that the custodian will not divest Texas oil and natural gas resources. For financial institutions that do not comply, the Comptroller will administer rules to have on their prospectus documents a mark resembling a stamp stating that the financial institution plans to divest from Texas oil and natural gas. Senate Bill 2146 would ensure that investors have access to the information they need to make informed decisions about their investments and that financial institutions are held accountable for their investment decisions. And with that, Mr. Chairman, I'll conclude my comments and be happy to answer any questions. Obviously, as a body, we've worked on this topic a great deal, and this is just an extension of the good work that we've done in previous sessions.
Thank you, Senator. Members, any questions for the author? Very good. We'll open public testimony, and the chair calls Hasib Abdullah. Mr. Abdullah, if anyone else wishes to testify on, for, or against Senate Bill 2146, please make your way to register at the kiosk outside this room, or with Ms. Babb, we can do a paper card over here. Mr. Abdullah, welcome back.
Yeah, Chair.
Get situated there and introduce yourself again for the record. Give us your testimony.
Yes, sir, Chair. Thank you again for your hospitality, members. This will be my last comment on any bill here. My name is Hasib Abdullah. I'm from the state, from Central Texas, and I am against Senate Bill 2146. I only represent myself. I'm against this bill in general because I believe it is an example of government overreach once again. As I'm not in the financial world specifically, but I will say generally, the financial world is very dynamic in saying things or asking them to sign off. Are you going to divest from Texas oil and gas or exploration and stuff? Is a little. It's much more subtle in the financial world than that. Some of them are doing it for certain companies because they think it's good for business. Some of them are doing it not for, maybe for other social and type of reasons. I do agree generally that Texas investors, when they go into mutual funds, they should be allowed to have that information in front of them. But I believe that this bill, there's better ways to do it, maybe in the private field as opposed to the state Senate. And I just think it's a government overreach. And I believe that the financial world is a little bit more settled than that. So that's all I have to say. I appreciate your time, Chair and members.
Thanks for your testimony. Senators, any questions for the witness? Thanks for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 2146? Seeing none, public testimony is closed. Bill's left pending at this time. If there's no other business to come before the Senate Committee on State Affairs, the committee stands in recess, subject to the call of the chair. Good morning.